This meeting is being recorded.
All right, so thanks everybody for attending. My name is Greg Hobson. I'm a partner and co-practice lead at the Institutional Consulting Group for Greenspring Advisors. At Greenspring, we provide fiduciary plan consulting and employee financial wellness services to more than 140 companies and organizations and nearly 50,000 employees that we help prepare for successful retirement. And personally, I've been in the retirement plan industry longer than I'd like to divulge, but let's just say I can make catch-up contributions to my 401k plan. So, that gives you some indication. But and before I introduce the guest of honor, I just want to kind of review the format and technology information. So we have a lot of people on the webinar, and everybody's line is muted, and we've got a ton of great information to cover. So we will be taking questions for you. I'll be trying to monitor that as Frank's going through a good portion of the presentation for questions. So you can go to the Q&A section of the Zoom toolbar, and I'll be able to answer that. And then finally, for those of you that are Society of Human Resources Management, the SHRM certification, we do have one PDC credit hour for that, which will show the activity code at the end. And we'll be emailing out certificates of completion for you with that information again on Friday or Monday. I'm not quite sure exactly when we're going to be able to get those out. We've got an intern working on that for us starting tomorrow. So I'll be getting that out for you so you can submit that credit. So now that we have that down, let me introduce our expert for today. And Frank Nessel is a senior consultant in Vanguard's Strategic Retirement Consulting Group, where he's responsible for compliance and technical services for many of Vanguard's largest clients. Working closely with Vanguard's ERISA legal group and their Strategic Retirement Consulting Group is devoted exclusively to providing business-focused compliance and consulting services for Vanguard's retirement plans clients. It's a diverse group of attorneys, consultants, actuaries, and benefit specialists, many of whom are nationally recognized, like Frank, with on average more than 15 years experience. And Frank is specifically responsible for assisting Vanguard institutional clients with the interpretation and application of compliance requirements, which I think is incredibly important because there's all these rules that come out, and we'll talk about some of those. It's really not only just how do you interpret it, but what does it mean? How do you implement that? So, and he's got over 40 years of experience. I did divulge his number of years of experience here in a broad range of employee benefit matters, including health and welfare, non-qual plans, equity-based comp plans as well, along with obviously qualified retirement plans, which we'll be focusing on today. So, we have the presentation up here that hopefully everybody can see with our lovely pictures. Without further ado, I'm going to introduce Frank, and we're going to kind of go through our agenda for today, which are a few topics. So number one, cybersecurity, which is a big concern, and we'll talk about sort of how that has come up and what that means for your record keepers and providers, as well as what you need to do as a plan sponsor and participants. Talk about lifetime income illustration and what that means for your employees in terms of what they're going to be seeing on their statements and on websites going forward. Electronic disclosure, which I think is one of the more confusing topics that has been out there, is what can you send electronically? What can't you send electronically? When do you need to send all this stuff? So we'll get into that. And then two topics, ESG or environmental social governance types of funds, and sort of the whiplash that they've seen of being, you couldn't use them, then you could, then you couldn't, and so forth. We'll talk about sort of the newest regs around that, and then proxy voting and what you need to know as a fiduciary from that perspective. So the first area that we wanted to talk about was really cybersecurity best practices. And Frank, basically, there was some guidance issued earlier this year, informal guidance. It wasn't sort of the typical method from the DOL. And it sort of, I don't want to say raised some eyebrows, but it definitely was something that, the industry's been working on for a long time, meaning record keepers and providers of the data. But, the DOL finally came out with some best practices. So what do you see going on at this point in time, and how do we, as plan sponsors and fiduciaries, sort of interpret this, and what should the best practice be from a fiduciary committee perspective?
Very good. Thank you, Greg. And good afternoon, everyone. Greg, is my sound coming through okay?
Yes.
Excellent. Good. Okay. So good to be with you. That's right, Greg. It was a informal guidance. So they didn't go through a regulatory process. There was no notice and comment period, et cetera. It basically just dropped this on the pension industry on April 14th. And a lot like the missing participants guidance that was issued January 10th of last year, it's informal. So in theory, what it's telling you is what they're going to look for on audit. And I can tell you that about 6 weeks after this guidance was issued, the audit letters that were sent out contained the information I'm going to show you on the next slide. So already plan sponsors were being asked if they were implementing what they had just, proposed on April 14th. Another thing to point out is many of the regulations that deal with retirement plans are solely focused on retirement plans. This one's a little different. What the Department of Labor said was that cybersecurity applies to all plans covered under ERISA. So the Department of Labor has jurisdiction over ERISA-based plans, not only retirement plans, but health and welfare plans as well. So in theory and in practice, this cybersecurity best practice information also applies to your health and welfare plans. Think about HIPAA compliance. So you're not supposed to be able to disclose personal health information. If that were accessed through a cyber breach, what might that mean? So I just wanted to point that out. They basically provided cybersecurity best practices for 3 different constituents. Ourselves as plan record keepers at Vanguard and investment providers, yourself as a plan sponsor, and then lastly, what your plan participants should be doing from a cybersecurity standpoint. Greg, perhaps the next slide. Okay, so record keepers, what should your record keeper be doing? For those of you that work with Vanguard, there are 12 questions or points on this slide. Everything from a well-documented cybersecurity program to conducting periodic cybersecurity awareness training, responding to past breaches, et cetera. We've prepared a summary of how we meet each of these 12 standards. Whomever your record keeper is, you should ask for that summary. What you want to do, the Department of Labor, for the first time on April 14th of last year, indicated that cybersecurity is a fiduciary responsibility. They had never said that before, not even informally in conferences and things like that. Basically, what they've done is elevated this to either a fiduciary or a committee oversight function. So I would, if I were you and you're part of the committee, perhaps make sure that your record keeper provides you a summary of how these 12 points are being complied with, and maybe just read that into the minutes once a year. That this is an ongoing review by the committee in the same way that you review your reasonableness of plan fees, whether it's investment management fees or record keeping fees. So, ERISA is a process-driven statute. As long as it's indicated that the committee or a fiduciary made a review and felt that the practices were sufficient, that's all you have to do. I know you all have other things you need to do in your business. It doesn't have to take a lot of time, but the process is perhaps most important. What's interesting to me is, in addition to these points, record keepers and other providers were already providing information around secure practices for cybersecurity. Things like the SOC 1 and SOC 2, Statement of Controls 1, with regard to financial statement impact and controls. SOC 2, IT, InfoSec type controls were already being provided. So this is an additional layer of cybersecurity that the record keeper should be able to provide information on. Next slide, if you would.
Well, Frank, I actually, just before we get to that,
sure,
I would say, I think what you're saying makes a lot of sense. I mean, we've been, starting this process over the last couple of quarters, meeting when we're meeting with our clients and the committees, having an overview and a review of those 12 best practices for protection of data and cybersecurity in general. So we've been doing that and reading that and having that as part of the minutes. I guess and most of the, look, for lack of a better term, I think most really good high quality record keepers are way beyond most of these best practices as recommended by the DOL. So, and including Vanguard, which had client meeting with Vanguard and one of their cybersecurity experts yesterday with one of my larger clients, and that was something that we read in the minutes. It's an important part, but you also think it should be part that it's not just a one-time sort of thing. It's maybe annually incorporating to make sure or ensure and reading in that, hey, the record keeper is following these procedures for cybersecurity purposes and protection of data for participants and plan sponsors. So you think that should be something we should be doing as well?
Yeah, Craig, they didn't indicate a specific time frame. I think maybe annually. The most I would, or the least I would do is at least biannually. I agree that these procedures and processes aren't going to change much from year to year, but nevertheless, I think it's helpful to read that into either minutes or acknowledge that the fiduciaries are aware of cybersecurity and are keeping on top of it. I will tell you, I've looked at a DOL audit letter, and they do ask if these practices were inquired about from the plan record keeper, and they ask for evidence of that. So if they're auditing plan year 2024, for instance, perhaps they might ask for that year, where's the evidence that you looked at this? So that's why I said annually. It doesn't have to take very long. And in fact, it could be a subsection or a subgroup within the committee or somebody reporting to the committee. Just a quick read into the minutes that it's been done.
Right. I think that's, as you mentioned, it's a process driven world, right? So,
yep.
As long as you have that process and it's incorporated, once a year as part of the review, and you can document that or biannually, even if you haven't made record keeping changes and that sort of thing, it probably makes sense to keep that on board just from a protection perspective.
Exactly. Yes.
All right. So moving on to the plan sponsors and the committee. So I think we touched on it a little bit already about maybe what committees should be looking at with their fiduciary advisor like Greenspring, but what else should we be thinking about or should plan sponsors be thinking about?
Yeah, I think it's really two things, Greg. First, making sure that there are adequate contractual provisions to protect, your plan and its participants from cybersecurity breaches. So we have what we call a master services agreement, and there's a specific section in there around cybersecurity and our responsibilities vis-a-vis, the provider or the plan sponsor's responsibility as well. And in addition to that, I think the plan sponsor has a responsibility to ask questions about, have there been any breaches? If there have in the past, how have they been resolved? Have there been any complaints by our plan participants around, and any access to their accounts that was unauthorized, things like that. So again, not a lot of time needed here, but certainly from a contractual standpoint. And again, I don't know that you necessarily need to modify your contract at this point with your record keeper, but the next time you renew or if you move to a different record keeper, just making sure that adequate provisions are in the contracts to protect your plan and its participants.
Yeah, I know we in a call we had yesterday, it was the notification part was a question that came up from the committee about if there is a breach of participant data in some way, shape, or form, how quickly is the plan sponsor notified, what's their responsibility, and so forth. And I think kind of understanding that part of it too, from as a fiduciary and overseer of the retirement assets of your employees, it's really important to understand sort of what that process might look like, so that you can be confident. And again, I think documenting that in the meeting minutes is incredibly important too. What's sort of that prescribed turnaround time?
Absolutely, that's right, Greg. Yes, absolutely. And then the last one, and this is if there are breaches, this is where it typically occurs with the participants. And there are, I don't know, 8 or 9 points here that your participants should take into account. So things like multi-factor authentication, when they perhaps go online to access their account at your record keeper, once they enter their username and password, there should be maybe multi-factor authentication so that they receive a passcode on their text, and they have to enter that as well. So that if somebody absconds with their computer or whatever, you need 2 forms of authentication, not just the username and password, but maybe a text message or something like that. Keeping contact information both secure, current, and changing it on appropriate frequency. What I deal with a lot of this, where there's situations where someone's account was accessed, just being a lawyer, and it typically is an ex-spouse or a trusted family member that has improperly or surreptitiously used the information to gain access to an account. And it's unfortunate. Sometimes it's older retirees that are compromised, and it's oftentimes a family member. So it's very important. It's very, very rare for somebody to have gained access through computer spyware or something like that. Not that it doesn't happen, but it's more often than not somebody just knowing the personal information. So if you can emphasize to your participants, on our website we have a whole area devoted to participant security and what participants can do to make their account more secure. Greg, any comments on that?
Yeah, I mean, I think you're 100% right. It's sort of the common sense thing, right? And what you mentioned about where those hacks are coming from, at least currently, are from ex-spouses, it's family members, elder abuse type situations, and that's why it's important, to, even with multi-factor authentication, sometimes that's not going to protect that particular person, but it is important from outside hackers, right? And eliminating that sort of risk. We actually, one of the other advisors on our team, Christian Stanley, one of the partners here, just put a sheet together, sort of a 1-pager for participant best practices that we'll send out to everybody on the call afterwards. It's still sort of in production, so I don't want to promise it's going to be the same day as the certificate, but we'll be getting that out to you here in the next week or two with some best practices you can potentially forward along to your employees so that they can help protect themselves. But again, it's a lot of common sense stuff. It's not even just around your 401k. It's about all of those things, like not using the same password for your bank account and your 401k, because there are websites that you can literally go to see which passwords have been usernames and passwords have been compromised. And if you're using the same password across multiple different platforms, if they get one, they're going to have more than one, and they're running scams to figure out what they can access. So using different passwords is a big key for individuals, and signing up for multi-factor authentication. I know that Vanguard requires that for on your record keeping platform for new participants over the last couple of years. Some providers do require it, some don't. I can't imagine a point in time in the next 3-4 years where that's not 100% required, because so many people are used to it. I know one of the vendors we worked with, they instituted it like 3-4 years ago, and it was like, oh, we don't want this for our participants, and they were like, no, we're doing this because you need to protect the data, right? There are very large balances in these 401k plans, and this is where a lot of assets are. So that's where the criminals are going to go, or where the assets are. So it's really important. So ensuring that your record keeper, as a committee member and a plan sponsor and fiduciary, making sure that they have great processes in place and great security protections in place so that your participants, are at as a limited risk as possible, right? But it's a 3-pronged effort of the record keeper, the plan sponsor, and the participant, kind of making sure that to try to limit that damage when it does occur, because it will occur, right? It's going to happen at some point where somebody's account's going to be breached in some way, shape, or form for whatever reason, and you just need to make sure that you're working with providers that are going to back that up and provide this reimbursement for those employees and that sort of thing. So kind of moving to a little bit of a different topic, Frank, lifetime income illustration disclosures, which were part of the Secure Act. So, this is sort of a new way. I always kind of think about the old commercials on television, if you remember ING, which isn't ING anymore, but they used to carry around these giant numbers for retirement, like 1.1 million, and they would carry it around, or 2 million or 500,000 or whatever it was. And I've always said, for years, people have no idea what that means. Like, what does that mean to me on a monthly basis? What does that mean to me on an annual basis? Because that's how people think, is how much do I make a year? How much do I make a month to be able to pay my bills? And when you show them 500,000 or 1.1 million, they don't know what that means. It's a lot of money, but does that pay my bills for the rest of my life? So.
Yeah, that great illustration. Thank you. And this is intended to try to address that, Greg. My concern with it is it doesn't go far enough. So as Greg mentioned, it's part of a law, Secure Act, that passed in late 2019. Congress directed the Department of Labor to issue guidance around basically an annuity type illustration. So taking that 1.1 million that Greg mentioned and changing that into what it would be as a single life annuity and a joint and survivor annuity, assuming that and there's some assumptions to these illustrations, that the spouse was the same age as the participant. So, and we can do that. This is required by the second statement that's issued this year. So the second quarter statement. So if you're a calendar year plan, that's the June 30 statement. Now your record keeper may be doing this earlier. At Vanguard, we've decided to hold off till the second quarter statement, which is the deadline, in hopes that we may receive additional either guidance here or some clarification. And I'll explain in a moment. There are a number of assumptions to these lifetime income illustrations. They've got to appear on statements once every 12 months. The assumptions include things like mortality. As I said, that this, if it's a joint survivor, that the spouse is the same age as the participant, et cetera. The one area that it does not permit, however, is a projection of what the current account may be at retirement. So I'm fairly close to retirement. What I have in my 401k is probably pretty close to where I'll be when I retire. My lifetime income illustration will look pretty accurate, okay? What about somebody just leaving college that has $5,000 or $6,000 in their account in your plan and is age 25? Basically, what this illustration requires is for the record keeper to look at the December 31 or the most recent quarter prior to the illustration, and to take that and just show what it would be as a single life and a JNS annuity type monthly payment. So for that 25-year-old, there's no projection based on potential future earnings, potential future contributions. And to me, that's where the downside is to this illustration. Great idea, but it's not going to be particularly helpful to the younger, lower balanced employees that have a potentially long working career to kind of save up. And my concern is, what will that mean for that younger employee? Will they look at that and say, $47 a month, I may as well not even bother with this and just get the new car or the house or whatever it is. So that's kind of the downside. We've asked for some clarification with regard to the ability to make the assumptions the same for everybody. Assume a 4% growth rate and a, whatever the contribution rate might be, 3%, whatever. They've not granted that. So that's the kind of clarification we're hoping for. We're also hoping that in addition to the statement illustration, maybe we can add a statement that sends the participant to a different area, like our Vanguard website, that does provide those projections to age 67, which for most employees will be their normal Social Security retirement age. So again, that's how we're looking at this. We'll wait and see if they provide any additional guidance. Greg, any thoughts on that?
Yeah, I mean, I think you're right. That's the biggest, the unintended consequence of sort of potentially acting as a detractor to contributing to the plan for younger employees. Because when you look at a lot of websites, whether it's, the Vanguard record keeping website or others, where there are illustrations, the assumptions are based on future growth, future contributions at your current level, potentially matching contributions if the employer has a matching contribution. So it can look a lot different, and can, and again, how accurate it is, that's a totally separate question, right? Because when you're 25 entering that information, a lot of things can change over your lifetime. So it's certainly not necessarily entirely accurate, but at least it gets you in the ballpark instead of saying this is going to provide you, 5 lunches when you retire per month. So certainly, hopefully there'll be some additional guidance. Do you expect that, what is your take? Do you expect to get some additional guidance on that prior to that June 30th deadline?
I doubt it at this point. We were hoping. I work, many of us at Vanguard are part of pension industry groups, American Benefits Council. I'm part of Plan Sponsor Council of America myself. And, these organizations had asked for, some additional clarification around, just what I just talked about. And there was some sense that we might get it. And I think we're too close to the deadline now to receive anything. So we'll provide the illustration. We're ready to do so. We have it programmed. It'll be on there. The good thing is participants typically, look to their web page just to see what their account balance is and that sort of thing. And that's maybe where we can catch them with a much more robust, meaningful illustration than what this is going to be on the statement. So,
right. All right. Makes sense. So moving into the next area, which is the final regulations that were issued by the DOL on electronic disclosures, which the world have been clamoring for. So, as they continue to add more and more things that we need to, and plan sponsors need to send out to their employees every year, fee disclosure, QDIA, automatic enrollment, the summary annual report, SPD, all the things that are required to go out to employees, new and old. It's a challenge, and in this age where we could, certainly not only save some trees, but also save a lot of time and cost. Could you provide some insights into, what those final regulations are and, how, what plan sponsors still might need to do in terms of potential mailings?
Yeah, I'd be happy to. So this has been a long time coming. The Department of Labor, and by the way, this is a Department of Labor regulation, so it's not the IRS. And as if you look at the bottom of this slide here, only ERISA type disclosures are going to be covered under this regulation. So things like safe harbor notices for your 401k, if you're a safe harbor plan, IACA or QACA notices, those are other safe harbors that are IRS generated or controlled. This doesn't cover that, but it does cover quite a few required disclosures: summary plan description, summary annual report, summary material modification, fee disclosure, QDIA notices for your qualified default, all those sorts of things, even benefit statements. So the Department of Labor's previous safe harbor was from 2003. So there's been a lot of development with regard to the internet, web usage, that sort of thing, even apps and text messaging and things like that. This regulation was really comprehensive. As you can see here, it was effective, just about a year and a half ago. So it was issued May 21. It was effective almost immediately. So, a lot of the record keepers weren't prepared. And one of the things you have to be prepared to do here is if you send an email with a link to a particular required notice, let's say it's the SPD, you as a record keeper have to be able to measure or capture what they call bounce back. So if the email is undeliverable, your record keeper has to quantify that and use, assume that since it wasn't deliverable, it's basically an election for paper. So you can make electronic delivery the default. it's voluntary on your part as a plan sponsor. So you don't have to do this, but you can make electronic delivery your default. The one thing you do have to do is issue one paper notice that indicates to all your participants. So the paper has to be sent to all of them that they have electronic delivery, how that will occur, that they can opt out of either individual electronic delivery. So I want everything except my SPD. I want that on paper. You can do that. Or opt out of electronic delivery entirely. The contact information for that, that's all on that piece of paper. Once that's delivered, you can provide electronic delivery to all with regard to all the documents on the left-hand side at the bottom of this screen for indefinitely. And that's different. The prior rule was that you can only deliver electronically in two scenarios. If you had a workplace email and part of your work function was to access a computer, to perform your work, or you as a participant gave permission to the record keeper to deliver electronically. This is a third safe harbor. Again, it's voluntary on your part, but if you adopt it, electronic delivery can be the default. There are two ways to do this. One's called notice and access. You can provide many of the notices on the left-hand side here on an intranet site at your company and just periodically update them as they become updated. You'd have to send an email to your participant indicating that you're doing this and have a link to that intranet site. That's one way of doing it. The other way is direct emails. Every time you have a new document, new SPD, new fee disclosure, new key data notice, you send them an email with a link and they can access it that way. So those are the two ways you can do this. Notice and access, that intranet site doesn't work for time-specific disclosures. So think about a blackout period. You're moving some investments and you're going to have a 5-day freeze. There's a blackout notice, a Sarbanes-Oxley notice required by the Department of Labor under ERISA. You can't put that on the notice and access intranet site. People may not be aware that you've added that, right? So those sorts of point in time notices have to be delivered directly through email. Everything else can be on that intranet site. So that's how this works. If you're working with Vanguard, we certainly can provide this. If you have another record keeper, I'm sure they'll be able to support it. Again, they have to have an adequate procedure in place to capture when these things are delivered and then to send paper. It's as though you got a bad address and you have to send it to the new address. The same thing here. Bad email address, we have to send it by paper at the address of residence of the participant. But apart from that, much better delivery method. Our communications people will tell you we're able to measure click-through rates, whether people open this stuff. We suspect a lot of times paper just finds its way to the trash, but these disclosures are much more readily accessed by plan participants. So I think it's a good result. Greg, any points?
Yeah, I mean, I agree with you. I think it's, certainly a good thing just for everybody's purposes, right? Plan sponsor, record keeper, participants, because you kind of get, some of these documents in the mail and, it's or years ago when you're getting them in the mail. I guess the big question is, around those Treasury and IRS notices, for automatic enrollment, which, that notice still has to be, delivered, but and safe harbor notice and the special tax notice on distribution. Do you think that there's any chance that that's going to, the Treasury or IRS is going to allow for those to be, formally, because you can do that if it's an email, a company email, correct?
Yes, that's correct. Yeah, you can still use kind of the old methods, if you will, to deliver these. So if a participant has said, I'll, accept email delivery, that's fine. You can do all these through email too. Or, pardon me, if they have workplace access, part of their job is to access a computer, you can deliver it that way. There has been talk that the agencies will come together and make this more uniform. Frankly, I think they're both distracted with a lot of other projects, and this just hasn't happened yet. But I do expect at some point that this will be made more uniform, and maybe some of these other notices will be amenable to this sort of default electronic delivery. So
it's always fun to be covered by two different agencies of the U.S.
yeah,
government,
right.
It makes it so much easier when that's the case. But I just wanted to clarify that you can still send it electronically. It's just really the old method, not under the DOL method. So if you've got participants that regularly access a work email address for purposes of work, you can still send that out. That way, if you're a manufacturing organization or construction or something along those lines, that might be a little bit more difficult. If people don't need to access it for that reason, you could figure out how to justify it. Potentially, you might still have to provide the paper, but obviously, terminated participants, those are the types of things that you have to mail out. But they might
have
not
paper unless they gave you permission, Greg.
Unless
we regularly send emails that would you like to opt into e-delivery kind of thing, and if they say yes, then you can do it that way too. But you're right, if they haven't done that, we're going to be sending paper, at least these 3 notices.
Right, perfect. All right, so kind of getting into sort of the last couple of sections, which, it's funny, I have clients that when I say ESG, they have no idea what I'm talking about. And then we have other clients that are, very much like, hey, when can we, we want to add this. We're getting a lot of calls from employees. Is this something we should do? Proxy voting is not a question we get a lot about, but it is an important function as a fiduciary that most people aren't aware of. So I think maybe we start with ESG and that the ability to add ESG types of funds or funds that follow environmental, social, and governance type of policies, and there are a broad spectrum of them. So we can't even get into what those actually look like, what's the construct of those, because there's a million different ways to sort of look at some of that stuff. And who is going to be happy with a decision around a particular ESG type of fund or sustainability type fund or whatever it might be. But from a fiduciary standpoint, in evaluating those, that's changed in terms of what's sort of been proposed in the fall of last year. So Frank, do you want to go through sort of what it was and then what is proposed at this point in time so that plan sponsors have an idea of what we're talking about?
Yeah, sure. Thanks, Greg. So Greg's right. I think in your opening remarks, Greg, you mentioned that this has been, kind of a ping pong ball depending on the administration that's in office, right? It's favored this time, now it's not favored anymore, and that sort of thing. This is the latest iteration in ESG. I can recall this being a topic even under the Clinton administration. So it's kind of ebbed and waned, over time, depending on the administration. Where we were, Greg, to your point, in the fall of 2019, and by the way, the reg became final in, I believe, either December of 19 or January 2020, was basically an investment duty regulation, and the emphasis was on what they called pecuniary interest. Under the prior regulation, a committee or a fiduciary determining investments had to look at pecuniary interest as the sole material factor in the prudence of an investment, in choosing an investment, for instance. Pecuniary factors were defined in 2 categories: investment performance and investment fees. Those were basically the 2 things that a fiduciary should consider under the prior regs with regard to the prudence of an investment, whether it should be selected, et cetera. These regs change that. They say that environmental, social, and governance factors can also be a material factor in deciding whether to add a fund to the plan, whether to maintain it, whether to remove it, et cetera. In short, whether it is prudent. What this reg permits is, and in fact, I think kind of requires that, and again, I'll emphasize that this regulation is in a proposed form at this point. So we don't have a final regulation. It was issued October 13th. There was a 60-day comment period. Comments ended December 13th. The Department of Labor presumably is reviewing comments at this point and may make adjustments or changes to the regulation. based on, the comments and suggestions received, or at least in the preamble, will kind of illustrate why they didn't, take into account some of the comments, et cetera. But so it's proposed. But what this regulation would say is that environmental, social, and governance factors can be a material factor in determining the potential future performance of an investment. To my knowledge, Greg, that's the first time that any regulation or other guidance from the Department of Labor on ESG has listed ESG as a potential material factor in future performance. In the past, it was always investment and fees. I'm not aware. Have you ever seen? I've never seen.
This is definitely a change in what, especially on the investment advisory side, that we can start to potentially, based on the proposed regulation, start to incorporate, and not have to necessarily worry about the other side of things, which is, definitely a new role.
Yeah. If any of you are multinationals, you might be aware that in Europe, ESG is not only a material factor, it's kind of the material factor in the choice of investments a lot of times. So we're very different in the United States. In fact, this first bullet under the consideration section says, plan fiduciary must always put the economic interests of the plan first. Can't sacrifice investment returns or assume greater investment risk as a means of promoting collateral goals. That's a great thing, because it still means that you as a fiduciary can look to the funds in your lineup and say, the fees are reasonable, the performance is either at or above the benchmark. We think that's a prudent fund. Again, if you were in Europe, that wouldn't necessarily be the case, but here it still is. But what the DOL said was that perhaps other factors should be considered material as well, such as they say things like climate change, et cetera, when evaluating the potential future performance. That fiduciaries, and what's fortunate for you all is you have Greenspring, kind of standing behind you on this, whether any of these factors should be considered in determining long-term performance. So, not only climate change, but the Department of Labor also pointed out areas like governance, things like governance practices, good compliance practices on the part of the company. So that would lead you to believe that maybe there won't be the potential for accounting fraud, that sort of thing. They even listed things like diversity, equity, inclusion as a factor to potentially consider. But I think their main issue was around the economic interest associated with things like climate change, and whether or not that might, in terms of the particular investment, lead to potential long-term outperformance or underperformance on the basis of whether a company was taking that into consideration. So again, you've got Greenspring kind of minding that, and that's a great thing, because you'll want to, I guess, kind of evaluate those sort of factors against performance and costs. So, but again, performance and cost are very important, and in my view, still paramount even under this regulation. The last thing this reg did was to permit your plan's qualified default investment, QDIA, to be an ESG type fund. In the past, your qualified default could not be an ESG, environmental, social, or governance type investment. Now it can. So for instance, if you had, I think 95 or more % of the target of the QDIAs in this country are target date funds. If you picked an ESG or a target date fund with an ESG type focus, that would be okay now under this regulation. So again, it's proposed. I don't think it should be relied upon at this point until it's finalized, because it could change. But what it signals to committees and to advisors like Greenspring is a change in the view of the Department of Labor with regard to the factors that are considered around the prudence of an investment in your lineup, and a much more flexible approach to ESG. Last point, proxy voting. Under the prior regs, there was some consideration that if there was proxy voting, you should measure the cost of that, we're potentially fighting a particular issue in a proxy vote against the benefit to your plan participants. That's kind of all been thrown out. And the other thing that the prior reg said was you didn't have to vote every proxy. These regs basically threw that out as well. They basically said that the fiduciary has, more or less an obligation to vote where a proxy is available. So that's all I wanted to cover there. Greg, any points, thoughts, comments?
No, I think, the proxy voting, as you said, and I'm going to go back to ESG because I got a couple things, but on the proxy voting side, that's a big change, right? Because I know a lot of, plan sponsors and, it's, how much of a fund do you actually own, right? How much are you going to have an impact from a voting perspective? So there was a dismissive approach to that. Especially for, most of the type size plans that we're working with, you get to the $1 billion plans and so forth. And we have, we've got some in that range, but it's, for a $5 million plan or a $20 million plan, like how much impact are you having on, a proxy vote on a Vanguard S&P 500 index fund, right? So, it's one of those things that we just, it's been dismissed. So, but it's important as those votes, as you receive those proxies, that the committee looks at those and actually, does vote on that part and documents it, right? Again, it's all about the process. So documenting that as part of the process is important. And, that's something to, consider. Now, on the ESG side, again, it's proposed, right? So this is not final. So don't, we're not coming in and swapping out fund lineups and saying, hey, let's go all ESG all the time, right? At this point. And even when that does happen, it's, as you said, it's a factor that can be considered. It's not a requirement to be considered. But for a lot of plan sponsors, especially some of our public companies that we work with, they are really trying to move in that direction. And, we have resources at Greenspring to Morningstar does a pretty good analysis from an ESG factor. They provide a score on a particular fund and how they're doing. And there's a million different ways to look at it in terms of, what a company or the underlying companies that are owned by the mutual funds, what they're doing, how they're doing things. Mutual funds and mutual fund companies have a bunch of different ways in terms of how they evaluate it, right? Is it, are they 100%, sustainable, or are they moving in that direction, right? You could talk about maybe, I'm not going to get into individual stocks, but you could look at like a big oil company, for example, that also, you say, well, that's easily eliminated, right? But if they're moving in the direction of providing, wind resources, right? Does that mean that, hey, well, there is some, they're moving, so, or solar or that sort of thing. So there's a lot of different ways to evaluate, a fund manager and what they're doing, but how that fund manager is evaluating the underlying stocks and what criteria they're specifically putting on. Is it, that they're there today, because that does limit the pool of stocks that are out there in the marketplace, right? Versus, are they moving in the right direction? And so there's a number of different ways to look at that. So thank you very much for the time. I know for all of you that are in the HR profession, you've been waiting 51 minets to get this code, so that you can stop listening to me and Frank talk on and on about ERISA and laws and regulations that make your head spin, and you go, geez, I'm glad we have, or hopefully I'm glad we have Greenspring as our advisor, and that we're in good shape and they're going to point us in the right direction. But that code is the activity ID, so you can plug that in. We'll be sending out certificates again here in the next couple of days you can expect an email from Alan Schlanger, who is a current intern of ours who started with us last summer, who is going to be starting full-time with us in June after graduating from Loyola University. So he's going to be our 4th intern hired at Greenspring, which we're really excited about. So keep an eye out, because that might be not a name that you're familiar with at Greenspring, but it's Alan Schlanger. So he'll be sending those out here in the next few days. And then additionally, as a follow-up, we will be providing that document that Christian Stanley, one of our partners, worked on for best practices for cybersecurity for your participants. So once we have that document completed and prettied up, we'll be getting that out to you guys as well, so you can provide to your participants, which is, again, another nice touch point when you go back to the first couple of slides about cybersecurity and what are you doing as a plan sponsor. It's a great way to help, if the DOL ever came in and said, hey, we looked at our provider, we looked at where they stood for those 12 best practices. We documented in our meeting minutes, you looked at the contract. We know there's, whatever guarantee there is for participant data protection. And then we also send our participants this. It's a great way to sort of enhance what you're doing and show the process that you take and that you take your job seriously as fiduciaries of your retirement plan, whether it's for 401k or 403b or otherwise. So again, really appreciate your time today. Really appreciate Frank and his insights and knowledge to be able to share with our clients and prospective clients. And we certainly appreciate that. We didn't have any questions, which means, Frank, we covered it perfectly, which I couldn't have expected anything different the way based on your knowledge base, but
I'm not sure that they're just so confused. They didn't know what
I'm sure that they're not. So again, we'll be getting those emails out. And if you're in the Maryland area, certainly enjoy the warmer weather that we're getting for the next couple of days while we have it. So thank you very much. And look forward to talking to you soon. If you have any questions about this, the meeting, any of the information that we went over, please reach out to your advisor from Greenspring or the contact at Greenspring that you have, and we're happy to help. So have a great day, everybody.
Thanks very much.